ASEAN mourning, including the Judiciary, profoundly mourning this period of grief. We have to still, in consonance with our mandate, to ensure that our country moves forward by allowing these kinds of talk to take place. The ASEAN Institute of Management is indeed a leader in the thought processes that the Philippines involves itself in as it forges a direction for itself in a future with the rest of the ASEAN. And in this way, I wish to honor my former employer institution, and I would be very sincere when I say that it has always been enervating for me to join any forum at the ASEAN Institute of Management. It is part of my life. I once served as executive director of what used to be called AIM Policy Center, what used to be called the Center of Washington CSIP, and now it's Rizalino Navarro Center. So I am very, very happy to be able to share this moment with you on a topic that is dear to my heart. Because when I started my discourses in international trade law, my master's thesis was really on ASEAN integration and whether the dispute settlement mechanism that had then been contrived in 1992 would augur well for a rules-based regional economic grouping, or whether it is indicative simply of more of the consensual way by which ASEAN had thus far been run. It gives me pleasure also to congratulate Dr. Steve DeCray for his leadership of this great institution. I am confident he will lead it to greater heights, as well as its new dean, Dr. Jikyo Kam, a lady who I am very confident will more than prove equal to the expectations that is thus thrust upon her. So we are going to talk about what is inevitably going to happen in 2015, a period, the end of 2015 has been designated as the period for the full realization of the vision of an integrated community of more than 500 million people of the 10 member states comprising the Association of Southeast Asian Nations, including, of course, the Philippines. Its combined nominal GDP exceeds 2 trillion American dollars. Now, I am not here to talk as an economist. You have more than enough economists in your rank to discuss that. But I will make a transition from the concept of the ASEAN as an economic grouping to how relevant the judiciaries in the ASEAN are in this move towards creating an economically integrated regional grouping. I believe the changing regional dynamics so far, and I will not go into a history of how the ASEAN transformed itself from the first time that its leaders sought to discuss a regional grouping in the 1970s. But let me just start with a general discussion of how, in fact, the changing global dynamics in the political and economic sphere allowed the ASEAN as an organization to transform itself into a genuine engine for the creation of larger markets for production, for trade and services exchange. Many of its critics in its earlier days used to not believe that ASEAN can progress into a more integrated unit. After all, they were talking about the inherently competitive nature of their products, other than the fact that many of the ASEAN countries were the production hub for many Japanese companies in the 70s and 80s. Critics were saying that ASEAN companies will just compete with each other for the subcontracting or manufacturing contracts that the other large developed nations would be willing to share with those companies. Not much was said about how, in fact, complementarity will give way to a more nuanced approach to business decision-making, and how, in fact, businesses, business leaders, smart as they are in the ASEAN, have found ways to harness the energies of the various peoples of the region and to make, in fact, ASEAN into a viable regional economic grouping. I would credit the year 1992, in which the agreement on the Common Effective Preferential Tariff was signed by the leaders of the ASEAN, the CEPT-ACTA, as in a real sense the beginning of ASEAN economic integration. Prior to the time, the move was just for greater coordination, cooperation, and people-to-people exchanges, and limited investment and trade agreements with each other. Now, this decisive move to integrate, by having a common preferential tariff platform, which was formalized later on in November of 2007, when the heads of these 10 ASEAN countries signed the ASEAN Charter, which envisions the establishment of an ASEAN community founded on the following pillars, rather. The ASEAN Political Security Community pillar, the ASEAN Economic Community pillar, and the ASEAN Social-Cultural Community pillar, under the principles of political cohesion, economic integration, and social responsibility, respectively. To my lawyer's eye, keen as I am about the human aspirations that undergird any agreement by formal institutions, I saw that there was a coincidental parallel symmetry between these three ASEAN pillars of the ASEAN community and the theory of the former director of the International Institute of Human Rights in Strasbourg, Karel Vassac, where Vassac classifies human rights into three generations. The first generation being of political and civic rights, the second generation being of socio-economic rights, and the third generation of communal rights. Now, why am I thinking of the ASEAN integration in terms of rights of people? It is because rights also talk about aspirations of communities. And like Vassac's theory, it appears that indeed the ASEAN Charter, if you are going to read it carefully, seeks to guarantee full and comprehensive human security to the peoples of the region by declaring among its purposes the enhancement of the well-being and livelihood of the peoples of the ASEAN by providing them with equitable access to opportunities for human development, social welfare, and justice, and also by declaring as one of its principles respect for fundamental freedoms, the promotion and protection of human rights, and the promotion of social justice. It thus appears to me clearly that there is a definite direction towards fulfilling the aspiration to address the whole gamut of human needs as far as possible, even at the community or national level. But it is really in the economic sphere that ASEAN integration has made important strides, and in fact, rapid strides. As spelled out in the ASEAN Charter, the integration consists of the creation of a single market and production base in which there is free flow of goods and services and investment, facilitated movement of business persons, professionals, talents and labor, and freer flow of capital. Besides having a single market and productive base, the ASEAN Economic Community is also envisioned by its blueprint to be highly competitive economically, with equitable economic development while continuing to be integrated into the global economy. Such heightened economic activities accompanying the establishment of the community has provided the impetus to a more rule of law-based approach from the concentral style adopted previously by the ASEAN. By rule of law, it is meant the observance of rules rather than the exercise of discretion. In a sign of progress from its earlier reputation, ASEAN is now growing teeth. And much like an infant, there will inevitably be teething pains. But note how the judiciaries of the ASEAN countries have responded to what we see is the push by our national governments towards this direction. My counterparts from the ASEAN, and notably from Singapore and Malaysia, have spoken of the need for the harmonization of commercial law in the region. And this is no mean task, considering the diversity of law in the region, unlike that of, say, Europe. I caution them continuously that although I understand the logic of harmonization, it is not up to the Supreme Court to dictate harmonization, except to the extent that it can promulgate rules of procedure that can facilitate recognition of judicial and other legal processes. But rather, the substantive matter of harmonization of commercial law is up to the national legislature, who has the constitutional authority to define the content and contours of commercial law. It is thus that while I appreciate the brave moves that they are making, we understand that the Chief Justices of the ASEAN have differing levels of authority to speak on these matters. And thus, my caution, but with the hope that eventually we will come to a place where indeed we are able to facilitate processes to the extent that we can facilitate those under the Supreme Court's watch. Indeed, the region's judiciaries have taken up the challenge of regional integration, with no less than the 10 Chief Justices at the forefront. Aided by the ASEAN Law Association, the National Committee Chairman of which is, in the Philippines, is Attorney Avelino Cruz. ALA, or the ASEAN Law Association, is a non-governmental organization of lawyers, including judges, law teachers, practitioners, and government lawyers. We held the inaugural meeting of the ASEAN Chief Justices on August 23, 2013. Never before have the ASEAN Chief Justices formally organized themselves until we met in Singapore and decided that rather than just being a parallel sideshow to the ALA grand event, we would take the initiative to face many of the legal issues in the region by forming our own group. And in the said meeting, my ASEAN counterparts and I agreed on the following objectives of the meeting. And we agreed that we would have an annual agenda henceforth, so that our mutually agreed goals will see flesh eventually. We agreed that we should promote close relations and mutual understanding amongst ASEAN judiciaries. Before this, justice to justice, judges to judges contacts have actually been increasing with frequency and on a variety and on an increasingly greater number of topics. Not only do we talk about environment, trade, human rights, communications, media, etc., we have gone to say that in itself, closer relations and interaction among the members of the judiciaries of the 10 ASEAN countries is good in itself. We also agreed that we will always provide a regular forum for the 10 ASEAN Chief Justices to discuss and exchange views on common issues facing the ASEAN judiciaries. We also agreed that we will facilitate cooperation and collaboration among the judiciaries with a view to accelerate the growth and development of the ASEAN region. And perhaps this is the one goal of the judiciaries that is closer to the hearts of the businessmen. We also discussed how to develop an internet portal so that there can be an improved flow of information on the ASEAN judiciaries. We thought that it would be best if we lead allowing the peoples of the ASEAN and even outside the region to understand how the various systems work, where the judiciaries will take the lead in making, to the extent possible, information on their judiciaries and legal system as transparent and accessible as possible. We also agreed that we should promote judicial education and training by collaborating on ideas to enhance training opportunities for judges and judicial officers within the ASEAN. We also agreed that we should harness this judicial cooperation by collaborating and sharing best practices in the use of court technology, case management, and service of court processes within the ASEAN so that we can help promote economic growth and development of the region. In the second meeting of ASEAN Chief Justices last September 19, that was 2014, this time in Malaysia, it was decided that we would have the Judiciary's portal of the ASEAN in English to reach a wider viewing audience at its initial phase. For the training of judges in the region, we would have a working group, and the training programs would be on a joint partnership basis between Indonesia and the Philippines. It was similarly decided that the working group will also be established on the matter of facilitating the service of civil processes within the ASEAN. And the next meeting will be held this coming March in our country, specifically in Boracay, where we hope to make greater progress for judicial cooperation in the region. Another example on a more specific field of ASEAN judicial cooperation, a topic I had actually referred to earlier, is the inaugural ASEAN Chief Justices Roundtable on Environment held in 2011. Actually, it was decided in there that there would be a common vision on environment for ASEAN judiciaries, where the judiciaries there resolved to help strengthen the enforcement of environmental claims in their countries. I am proud to say that the Philippines is seen in the entire ASEAN as the trailblazer in the legal protection of the environment by the courts. This trailblazing role, I am proud likewise to say, but I would be truthful in saying this, is recognized not only in the ASEAN region, but also worldwide. This is because we had enunciated the doctrine of intergenerational responsibility in some of our previous decisions, which allows litigants to sue on behalf of generations yet unborn. We also were the first to create the rule and procedure for environmental cases with novel features such as the writ of kalikasan. I know for a fact, however, that the business community still has much to learn about the writ of kalikasan, because every time that term appears in the newspapers, there is an inevitable nervousness among businessmen as if we are already issuing a TRO. A writ of kalikasan is nothing but an order for you to answer. Unless we issue a temporary environmental protection order, it's nothing but a direction for answers to the allegations of environmental damage to be set forth by the respondent. Singapore, for its part, launched the International Framework for Court Excellence. This is similar to an ISO certification system. It is a self-assessment evaluation tool that uses questionnaires and checklists to improve court performance. In 2011, we applied these tools in 60 lower courts in our country. And there are calls right now, and we are studying these calls for these framework for court excellence to be adopted to suit the ASEAN context, as very well enunciated by Singapore's Chief District Judge on. If members of the ASEAN come together with a common commitment to pursue court excellence via a concerted effort in adopting a common framework like the International Framework of Court Excellence, it will send a strong signal to the world at large that we are united in promoting the region's stability, economy, and prosperity. This will surely boost our credibility and attractiveness to investors, whether within and beyond the region. The commitment to excellence is also something that I have applied to the Philippine Judiciary since I became Chief Justice 3 years ago. In the context of the integration of the ASEAN, I feel such commitment to be even more pressing. Indeed, it is a must for our judiciary to be world-class, for the Philippines to have the maximum benefits from such integration. If we in the judiciary cannot put our own house in order and create a legal environment that is stable for business, how can we invite and attract guests in the form of foreign direct investors? And in keeping with the Latin maxim, nemo dat quod non habet, no one gives what he does not have. How can we be a source of judicial best practices to be emulated by our ASEAN neighbors? As Chief Justice, I am both leader and manager in this immense endeavor to make our judiciary world-class. In the first task, I have to set out a vision of the Philippine judiciary, and in the second task, I have to look for ways and means to implement the vision. The latter is tricky, for I have to do a delicate balancing act between several interests, ensuring transparency while protecting the institution, ensuring accountability while encouraging people's morale, assuring job security while upgrading performance standards. Much like the way ASEAN has incrementally evolved towards a rule-based community, so must I introduce reforms in the judiciary with a careful eye towards the signs of the times. In all these, I, in the same way ASEAN was originally conceived, must have the consensus and support of my colleagues in the court. At this point, let me introduce you to the 4 pillars of the judicial reform agenda. I will just very briefly introduce to you these pillars through which judicial reform is being pegged, and then I will make a very personal statement on leadership. The first pillar, I have thought that if we are ever going to make a difference in the lives of Filipinos, there must first be institutionalized integrity and restored public credibility. We must restore public belief in the Filipino judge. I know that this is a hard task in the age of cynicism. But we must do this nonetheless. We must institutionalize integrity and measure the rise or fall of the credibility of our judges by the appropriate instruments. 5 of the proposed components of this first pillar as examples would be creation of a pool of future judges where we are looking even at the most talented young people in the law schools as members, future members of the judiciary, and where we will be proactive in attracting the best, even among practitioners who have made remarkable note of where we have already noted their remarkable successes in their careers. We hope to also transform the Judicial and Bar Council as a sharp headhunting agency, a sharp recruitment, selection, and promotion of the promotion agency of the Judiciary, as the Constitution intended it to be. We are doing what we can to strengthen the ability of the Office of the Court Administrator, the Bar Confidant, the IBP, and the Supreme Court and Bank and in divisions to monitor the performance and conduct of judges and lawyers. We are going through an accelerated pace of strengthening values education, mentoring programs, and information campaigns in the context not only of the of court processes, but also in the context of law school education, of the continuing professional education of lawyers, and of the career enhancement of judges. And we are creating a two-way communication mechanism between the judiciary and the legal profession on the one hand, and the public on the other, so that this will necessarily include the effective discipline of the bar and bench. If you had noticed, and we had been trying to convince more people to look at our websites, we have actually been quite aggressive in disciplining judges and lawyers, and you would really find some of the administrative cases that we have been publishing. Very good case materials, even for the business school, because these are really human interest stories. What leads people to go astray? Why does a clerk of court pilfer the funds in her custody? Why does a sheriff extort? These are good case management studies, and they're freely available at our website. The second pillar, of course, I understand keenly, because I had written on this, that the decision to litigate is fundamentally also an investment, also involves an investment paradigm. In other words, a businessman would measure his risks and his chances of winning, as well as the budget, before he makes a decision to litigate. But even before that, the decision to invest is going to likewise be informed by what he thinks would be his investment parameter when the contract turns out to be breached, or where the relationship turns sour. And I know that it is key to good governance that the level of risks is fairly certain, predictable, and within a measurable range, so that it behooves us to create a strong conviction on the part of the business community and the public at large that there is predictability, rationality, speed, responsiveness, and constancy in judicial actions. We must be credible, not only in the lack of dishonesty in our dealings, but also in terms of in the reasonableness of our judicial actions. And with these include decisions and orders that must be seen as fairly predictable and reasonable by the public at large. This will be a sign of our competence, our independence, and probity, constitutional qualities that are required of every judge. So that what are we doing to bring this about? The first example of this second pillar is a major decongestion program that is now happening now at all court levels, from the Supreme Court down to the lowest trial court level. There were, as of 2 years ago, an estimated more than 600,000 cases in the first and second level trial courts. We hope that we would be able to address this by making a significant dent that after 5 years they would be halved. There are indicators of our success in this area, because the pilot program that we had there, where we had the major Judiciary, the congestion program, and the electronic court system, resulted in a 30% reduction after 1 year among 33 courts in Quezon City that was the subject of this pilot program. And I hope to be able to come back to you to give you even more glowing figures when the full gamut of the decongestion program has ripened in Quezon City. Imagine what we can do if we replicate this in other areas of the country. And right now, we are doing that in several countries, in several cities, Angeles, Davao, Cebu, Makati, Pasig. We are spreading these programs all over the country. The goal here is also to make sure that there is enough depth in the docket, the lowering of the dockets of the regional trial court judges so that they can fully implement a continuous trial system. Now, just imagine if it had reduced the docket of these 33 Quezon City courts by 30% in 1 year's time. But the problem is, as our populations keep on growing and people start believing that they can get a fair shake in court, there is now, we are noticing an increasing tendency of case filings. That is the bad side of progress or improvement on our part. We are looking not only at decongesting the dockets and moving these old cases fast, we are doing also, as an effect of our measures, effectively decongesting jails. And the figures are not yet with me, but in a few months I will be able to report the number of detention prisoners that have been released as a result of this massive program. Every now and then you would receive a media release of how many prisoners were released that we found out should already be released, either because the maximum sentence has already been served in detention even while their trial is still going on, or there are reasons that they should be released under existing laws and procedures. We are also coordinating with public prosecutors and attorneys so that delay is not occasioned. Everyone thinks that it is the court that is to blame, but what many people do not realize is that the judiciary is just one part of the entire justice sector. If you have no prosecutor, then the judge is forced to postpone the case. And the case postponement will take maybe 4 to 6 months. So that results in delays. If you have no public attorney to defend the accused, likewise, the judge will also be forced to postpone the case. The judge cannot unilaterally take action unless the accused is represented and the state is represented. That is why I keep on harping and asking Secretary De Lima, who also mentioned this to the administration, that the prosecutors' ranks must be filled immediately, because this is one major cause of delay of trials of the accused and the unnecessary prolongation of their detention. We are also very careful right now in stabilizing jurisprudence. I, as Chief Justice, have been very careful, making it my personal responsibility to ensure that the decision that comes out from one division does not conflict with the decision that comes out from another division. That takes an inordinate amount of time on my part, but I simply have to do it. Because unless practitioners, law students, and law professors see a remarkable improvement in the quality and consistency of judicial decisions, there will not be enough faith in the judiciary. Where we are also fast-tracking many amendments right now, and you have already seen since 2012 the amendment of the rules that allows judicial affidavits. We now have the jail decongestion guidelines. We have now the Quezon City pilot guidelines, and we are looking at everything possible within our constitutional mandate to cut down litigation time. Right now, the priority is to do these efficiency processes among detention, for criminal cases, especially where there are detention prisoners involved. Eventually, we will be coming out with an announcement which I think will be welcomed by the business community, where we are looking also at expediting cases involving commercial agreements. We are also improving our case management systems through the electronic court system, because the idea for me is that I cannot be a good manager if I cannot see the data on real time. Not only are our collections reported on a real-time basis, likewise, case disposition and case filings are not yet available to me on demand. Any manager knows that that data is so critical, because to any manager it is similar to a production backlog that must be immediately addressed. So also in the judiciary, I must be able, together with my colleagues, to be sensitive to where the problems are the most significant and where emergency measures need to be taken. If you had noticed, the court in the Ampatuan, in the Maguindanao massacre case involving the accused Ampatuan family, bent over and for the first time issued special rules to expedite the litigation of the cases before the Taguig Regional Trial Court, making the judge handle exclusively nothing but the Ampatuan case, but also giving her 3 assisting judges, relieving her of any other assignment, and allowing her to rule even on a piecemeal basis and even without awaiting the decision on incidents that have been appealed either to the Court of Appeals or to the Supreme Court. This is how proactive this Supreme Court is. It sees a problem, it will address it. Given our constitutional limitations and our budgetary resources, I can say with a straight face, we have been doing our best and we have not stopped day and night to try to bring about change. I know the change will be long in coming, but it is definitely starting to be felt. The third pillar is the improvement of our systems, processes, and infrastructure, and we have already inaugurated electronic courts in Kansas City. We are rolling it out now in Makati, in Angeles, in Lapu-Lapu, in Davao, and in several other areas. And we hope that by the end of 2016, we would already have covered 25% of all cases in lower courts covered by an electronic automated system. So you can just imagine the amount of money and training and monitoring that is required in order to do that. The idea, eventually, is that we will have an integrated system where, as Chief Justice, the court administrator can just click on her desk the status of any case in the land, so that I would already know whether there is basis for any complaint from you that in fact a case is being unduly delayed. This way, the judges also are able to monitor the number of prisoners that are still in detention cells. And there is an alarm system that tells them that action must already be done with respect to a case. So even on a personal basis, they have been so gratified to receive this kind of assistance through information technology. We are also looking at internationally acceptable certification processes for our most critical processes that are appropriate to the Philippine judiciary. We are also in the process of asking for more funds so that we can build efficient courthouses and storage facilities. We are now creating standardized judicial and legal forms. And for the experimental courts, they can just now run through a checklist to make sure that there are no elements that are missed. And these forms were created by the judges themselves. And the good thing is, these judges are so generous that they have allowed even forms that can be used by the prosecutors in the system. So the judiciary is generous in sharing its knowledge and its resources to all sectors in the justice system. And we are trying to standardize important judicial administrative processes, including detailed manual of procedures, and we are looking at how best to automate all the processes that can be automated and to decentralize those processes that should really be decentralized. These are indeed very huge tasks that an organization as big as a 30,000 strong judiciary is facing. So you can just imagine the kind of decisions that have to be made every day. And the fourth pillar, of course, all of this cannot work unless we have effective and efficient human resources. And we want an input-output analysis so that we can identify the number and qualifications of required personnel in order to produce efficient delivery of justice. Such an analysis has not yet been done. For example, did you know that the creation of courts is purely a function of Congress? And Congress has not had a guideline in where courts are going to be located. It has completely been dependent on the political play inside the legislature, so that you can have many courts in a particular area that does not need them, and very few courts in areas that are in dire need of them. We are in discussions with legislators right now so that we can have a standard guideline for determining the needs of the judiciary. In fact, that is a laudable move among some of these legislators who are saying that why don't we give you, the Supreme Court, the power to redeploy your resources instead of us predetermining where the resources will be put. Why don't you do that? We are waiting, of course, for such legislative amendments to take place in the hope that we can really have an intelligent system of resource deployment. So that we have to, at the same time, professionalize and upgrade the salary grades of personnel ranks in the judiciary, manualize all standard operating procedures for every position and in every geographic area, because you can see not all geographic areas are blessed with the same physical attributes. Some may have no connectivity, some may have no banks where the clerk of court can easily make deposits of the judicial funds that they're able to collect. We also are seeking the upgrade of the skills of court personnel by continuous training, and we hope to have an effective performance evaluation, rewards, discipline, and promotion system, and eventually, of course, rationalize all of these requirements on a per-court, nationwide basis guided by reasonable policies and principles. And of course, all of these strategies, I acknowledge, have been able to devise in a large part through my years of training and or experience as an economist, an administrator, and as a litigator before my appointment to the court. Keeping in mind that the dispensation of justice is not the responsibility of the judiciary alone, but also that of law enforcement, prosecution, corrections, and community pillars of the criminal justice system, our reform efforts, and this is key, must also be in tandem with reform efforts of the other partners of the criminal justice system before it can bear fruit. And may I say, this translates as well to the practicing bar when it comes to civil cases. In the near term, which I consider to be between 3 to 5 years from the start of my term as Chief Justice in 2012, I am optimistic we may be able to see some significant indicators of success. And I have already shared some indicators of success even right now, although on a limited basis, because the projects are still in pilot mode. So I believe the success of reforms in the judiciary will help ease the integration of our country in the ASEAN community. And judicial reform, genuinely improved delivery of justice will be one of our country's concrete contributions in the attainment of an ASEAN that is fully committed to the rule of law. Now, to my personal statement on leadership, while I may have been able to convince some of you, hopefully by this time, that there is a plan of action that has been set in motion for the judiciary, what I'm going to say next is beyond any reform blueprint on paper. Leadership to me is being accountable for the kind of life that I lead in public and in private. If I cannot maintain internal consistency by being a just human being, if I harbor malice and ill will, and if my call for integrity is not authentic, then I am not leading people, I am only deceiving them. To be a leader is to be willing to examine oneself and to be examined by others, whether to the best of my human capacity, I am faithful, whether the motive for reform is unadulterated, whether the vision is being constantly carried, and whether as leader, I continue to authentically speak of and live the noble human values that can elevate the judicial community to the heights that it has set its eyes on. Ultimately, it is a matter of the heart and will. A good leader must ensure that in her heart of hearts, there is always this constant striving for perfection and excellence in the context of the service she has chosen. It is a laying down of oneself for the sake of the community she has vowed to serve. Thank you and good afternoon.